Welcome, all C3RF members across Canada, indeed around the world, and a special welcome to our Veterans for Freedom folk who are viewing this on their dedicated streaming channels in the privacy of their own homes. It is a real pleasure to have with us today for our in-hot session, the Honorable Brian Peckford. Brian is an honorary patron of C3RF, and by way of introduction, he doesn't really need one, but in March of 1979, Brian won the Newfoundland Labrador Progressive Conservative Leadership Convention and became the third premier of the province since Confederation. He was, at 36, the youngest First Minister of Newfoundland since the first Prime Minister, Philip Little, in 1855. Brian became a strong advocate of provincial rights as manifested in his efforts to gain some control and revenues from the newly developing offshore oil and gas resources, culminating in the Atlantic Accord. This groundbreaking agreement brought revenues to the province as if the resources were on land. Over $30 billion to date has been accrued, and a say in the management of the resource has been gained by the province of Newfoundland Labrador. Brian was involved in the constitutional patriation process of the early 1980s, leading to the Constitution Act of 1982. It was Newfoundland's proposal presented at the conference that led to the breakthrough. Brian is the only living First Minister of that constitutional process, and he's a very honored guest here at C3RF in Hot. Brian, thanks so much for joining us. It's a real pleasure and honor to have you on board.
Thank you, sir. A pleasure to be here always.
As you can see from the intro, you've been a pretty busy man, and you've been involved with some pretty big dealings with regards to Newfoundland Labrador, which is, I guess, forever grateful for your efforts there with the Atlantic Accord. And of course, being the last living First Minister associated with patriating the Canadian Constitution is no small task as well. But you have been busy. I'd like to home in on more recent events, and that is you and a few others, Maxime Bernier and a few other litigants have taken the travel mandate. Remember the vaccine travel mandates? You took those into the court system, and it went into the court system. You were arguing that those travel mandates were unconstitutional, and you fought it all the way up to the Supreme Court of Canada. And the Supreme Court, after reviewing the appeals below, it ruled that it did not want to hear about your vaccine travel mandate argumentation. Could you talk about that, about your initial feelings on hearing that from the Supreme Court?
Yeah, sure, I'd love to. Just let me give a little bit of context. During the COVID period, when these mandates and stuff, lockdowns were coming in by provincial governments as well as by the federal government, and I was arguing against them and opposing what was going on, I thought I had to sort of walk the walk as well as talk the talk. And that's why I decided that I should initiate some kind of action against what was happening. Then I had to decide, and I think this is very important for people to understand, what particular item I would choose to litigate. And because the federal travel mandates were national, I thought that that was a more appropriate subject matter to litigate, because it would therefore affect all of Canada, Canadians, and Canadians would perhaps become more associated with it and understand it better than if it was a mandate in BC or a lockdown in Nova Scotia or PEI, and you'd have to get into the weeds of a particular provincial action. But a national action would affect all Canadians. And a lot of Canadians were going to be affected because they were traveling and had work activities throughout Canada, that this would be trigger a better understanding, an easier understanding of litigation on the charter. And so that's why I chose the federal government's travel mandate, which violated the mobility rights contained in the Charter of Rights and Freedoms.
That's right.
And other Canadians joined in with me on that litigation. Mine is not the only name. Mine is the first name on the statement of claim, but there are several other Canadians there, all of whom have been affected in different ways. Some, for example, a person in Ontario who had a business in Ontario and also in Yellowknife and now couldn't travel. to conduct his business, was prevented from conducting his business because he wasn't vaccinated, and therefore came under the travel mandate or the travel ban. And then other people who had family throughout Canada or overseas and were prevented from traveling, and people died as a result, and they weren't able to help their families. So there were a variety of people as part of the litigation, including then later Maxime Bernier, head of the People's Party of Canada, whose lawyer joined in with my lawyers and our lawyers to take it all the way through. So in going through the federal travel mandate, the first court that would hear under the law our litigation, it was the Federal Court of Canada. Right. So we applied and litigated to the Federal Court of Canada, arguing that this travel mandate was illegal or unconstitutional under the mobility rights of the Charter of Rights and Freedoms. Now, I want to say that, because people might forget, that through this litigation, this initial litigation in the Federal Court of Canada, our lawyers were able to prove through testimony given by the federal government itself that there was no science behind their decision. Okay. This is extremely important as we move through the two other courts that heard it. Now, even though that testament was there on record within the court itself through discovery, even before it became public, it was known to the judge that there was no science behind.
Here, Brian, can I just recap the evidence that you're talking about, because it is extremely important. The evidence you're talking about is your lawyers went in and interviewed personnel authorities from Transport Canada, who was the overriding authority associated with the travel mandates. Yes. They talked to those authorities and asked, okay, where did you get the notion that this is bad for travel? And they said under oath that they tried to get that rationale from Public Health Agency of Canada, and they couldn't get it. All they got was the old stiff arm. Yeah, so that's the kind of evidence that you had on board during that course.
But this is extremely important because when the federal court decided after our hearing that they would not rule on our arguments and use their own created technicality of mootness,
right?
They were essentially saying, and this is consistent then to the next two courts, consistently saying, we don't care whether there was any evidence to substantiate what the federal government did to deny rights and freedoms to Canadians, because it is no longer, the mandate is no longer in effect.
Okay. Right. So let's explain mootness, please, Brian, for the audience. What is mootness? What is that all about in a legal term?
Well, the way, and remember, it's not in the Constitution. Mootness is not in the Constitution. It's not in the Charter. No. It's something that was created by the court itself. Like if you wanted to one day decide for your organization you're going to bring in a particular rule, right?
Yeah.
And you did it on your own, and therefore stopped people from doing things. This is what happened in this case. So the court has brought in a rule whereby in certain circumstances, this whole thing is no longer relevant, no longer of any importance. And therefore, we should establish a rule to make it more efficient for the court that we won't hear this, because it's frivolous, it's tedious, it's irrelevant, and really no longer has any effect. It is this rule that they used, even though almost 6 million Canadians were denied their rights and freedoms for 8 or 9 months during that COVID period, that suddenly, because the time the mandate was no longer in effect, that the rights and freedoms that were obviously broken by the federal government had no meaning, had no relevance, had no importance. In other words, Brian, the charter is only important at certain times when the court decides when it is relevant.
How could they even use that argument? I mean, when the travel mandates were taken off by the government, the term they used was they were suspended.
Exactly.
weren't permanently
And that's
with.
the other point. They weren't taken off. They were suspended, and with the proviso that they could bring them back at any time. The minister said that. So this is the context into which Canadians have to understand just how fundamental a decision the federal court made when it said, we won't even entertain anything to do with your argument because of this silly mootness argument. And so we lost in the federal court. The judge ruled against us. Yeah. We appealed it to the federal court of appeal. That was the second court. And I go through this because I want people to understand what the system is. Yeah. For federal legislation, right? There's the federal court, then the federal court of appeal, then the Supreme Court of Canada. Yep. And so we took it to the federal court of appeal. And once again, they decided, they confirmed the decision of the federal court. We're not going to hear it. This is because of mootness, and therefore it's over. So then we appealed to the Supreme Court of Canada. Now, my point on all of this, which most people, most lawyers don't take up as much as I do. I am very familiar with the Supreme Court of Canada. Okay. Yes. I'm more familiar with the Supreme Court of Canada than a lot of the lawyers who fought my case. Because as Premier, I went to the Supreme Court of Canada as it related to the Upper Churchill Falls contract. Yes. Okay. And then, and by the way, in doing that, I consulted lawyers all over the world who were engaged in constitutional matters as it related to dominions within the British Commonwealth. Okay. So I'm not unfamiliar with all of this. From Australia to Scotland, University of Edinburgh, where we had the lawyers consulted, to people in the United States, to people in England. Mm-hmm. Okay, people in England, to people in Canada, anybody, any lawyer worth his salt anywhere in the world who had done anything as it related to constitutional matters. Okay. Yes. Within the British Commonwealth, within the British law system, we consulted. And so I went to court on that. I also, as Premier and through the cabinet, went to court as related to our offshore oil and gas resources and ownership. Once again, consulting people widely all over the world. So I was very familiar. So the reason why I took it to the last stage was because I wanted Canadians to understand what the highest court in the land, Supreme Court of Canada, was going to say on this issue, right? Yes, yes. I wanted finality to it so that nobody could ever say I didn't take it all the way and exhaust all possible avenues of appeal. And the other reason why I took it there, Russ, which is very important from my point of view, and which I think a lot of Canadians will appreciate, is that given this understanding that I had from back when I fought it, the Upper Churchill contract, all the way to the Supreme Court of Canada, when I fought through the cabinet and through our lawyers, I was familiar in talking and consulting with all of these lawyers on these two separate cases, the machinations and operations of the Supreme Court, okay? Besides knowing a lot about it because of my involvement with the federal government over many years. People don't realize and would forget, and a lot of people wouldn't even know and would have no reason to know, that in 1974 was the first year that I got involved as a minister in a provincial government with the federal government in a meaningful way, okay? I was a minister of municipal affairs at that time, and the ministers of municipal affairs for Canada appointed me to represent the provinces in ongoing talks with the federal government on municipal law and how it impinged upon the Constitution and where and all that kind of stuff. So I've been involved with federal government matters as it relates to the Constitution and to law since 1974. That's
extremely interesting. In 1974, you must have been just a young tad, just out of your 20s at that time frame.
Yeah, exactly. I was 29 when I got elected in 72, so I was 31 years old.
Okay.
And I was representing all the provinces of Canada then.
No moss growing under your feet, Brian. Let me tell you. No, but this is very interesting. You raised a question in my mind. You know, I didn't know that you did all these consultations with dominions all around the world in regards to the Supreme Court. But in all your consultations and discussions, what what is the obligation of a Supreme Court to hear a case in its fullness? Now,
Precisely, and this is the I'm glad you raised it that way, and you're the only person that has ever raised it that way, and I thank you, and I'm very grateful for that, because if you look through British law, you look through the fundamentals of our constitutional system, it all comes back down to or sort of British common law, which is common sense, which is what's reasonable. Okay, it's like Section 1 of the Charter, demonstrably right justified. What's demonstrably justified, and that's what it comes down to. And this is where the judges, and this is where justice has failed us, and all we got is little legal technicalities. We have moved from a concept of justice and common sense, which is supposed to underpin the Constitution, to one of technicalities like mootness, which therefore denies justice to the people of that jurisdiction. And listen, I also went to London during the Patriation Constitution. People don't realize that. I was in London talking to constitutional experts on behalf of the provinces, because we opposed what the federal government was going to try to patriate unilaterally. Trudeau Sr. was. He left the table in our negotiations and went off on his own and passed a law to go ahead and patriate the Constitution with his own charter.
Okay.
Okay. So I was I was one of the premiers that was chosen to go to London, and I was in London speaking to the House of Lords on BBC television, debating the constitutional experts in the United Kingdom during that period of time. So I got a fair amount of familiarity with all this. I don't usually talk about it, but now that it's all over,
I'm glad you are talking about it.
Yeah, and it's like Mr. Rouleau in the Emergencies Act and the commission that he had up. My name was put forward to be a witness at that, and he turned me down.
Okay. I wanted to ask you that because with your background, with your experience, the last living First Minister responsible for patriating the Charter, I would have thought that you would have been consulted left, right, and center on over the past 4 years. But was that not the case?
As a matter of fact, my own government of Newfoundland and Labrador threatened to take me to court because I asked them why they didn't go to court, because they have the power. All the provinces have the power to do a referral to the highest court on anything that they want to determine whether it's constitutional or not. So I wrote all the premiers asking them, why don't you do your reference case, right? Your referral case, because you have the power to do that. Cabinet has to just pass a minute appealing this to the highest court in your province, and the court is bound to hear it. So the provinces could have just found out whether, in fact, they had any constitutional validity in doing what they were doing in their respective provinces. And when I wrote the province of Newfoundland, where I served as premier for 10 years and as an MLA for 17 years, and was responsible as premier for the patriation on behalf of the government of Newfoundland and Labrador and all the other court cases I took, they wrote me back. The premier didn't write me back. He sent it to the Department of Justice and said to the department that they were a client, and so therefore they could not release any information of why they did or did not do a referral.
Oh my goodness.
And that if I released their decision, and their decision was, I'm not going to tell you what my decision is. That was their decision. That was their decision. Then they would reserve the right to take me to court for releasing that information to the public.
So after all that experience, all that dedication in Newfoundland, they basically said, "What have you done for us lately?"
Exactly. See you around, Joe.
See you around. I got this question of mootness has got me going here, because I'm just recalling now the recent case with federal Judge Mosley. He took on the Emergencies Act invocation as to whether or not it was reasonable. Right. And during that case, the federal lawyers, they raised this mootness point. They said, "Hey, no need to even talk about this because the Freedom Convoy is over. The Emergencies Act has been called off. It's no longer in play. This is moot. Don't do it." But he looked at the case, and he actually went into the evidence and said, "Wait a minute, mootness does not apply, because mootness, to be moot, there has to be a public disinterest. There's no interest in the public to proceed with this case. So he said, there's great public interest in this. There's a public thirst to see what the heck is going on with this martial law declaration. He says, mutinous, no way.
Exactly. And of course, the federal government has appealed that decision, right?
Yes, they're appealing now. They're appealing
now. Appeal that decision. And you can bet your bottom dollar, right, that there's a lot of talk within the judicial system of cocktail parties and so on, where they all get together and whatever over how they're going to approach dealing with Mosley's decision, because obviously, given the Supreme Court of Canada decision on the travel mandate, they are not amused by what Mosley's had to say, and he's upset the apple cart for their continuity and consistency on being in support of a government that is doing unconstitutional things. So
he upset the apple cart, Brian, because he actually went in and did the Section 1 duty to determine whether the loss of a right was demonstrably justified in a free and democratic society. And he said, no, this wasn't reasonable.
And the sneaky part of all of this, and it happens with the lawyers too. Many of the lawyers in coming back to me and talking to me about this, or my reading of their comments in the public domain and whatever, have talked about reasonable, right? If you read Section 1, right, the operative words are demonstrably justified within a reasonable context, okay? So demonstrably justified, but they try to push off dealing with demonstrably justified by talking about the word reasonable.
Yes.
And this is a way to dilute the power of Section 1. This is a way, and they've been very successful in doing it. In the same way, by the way, you got me going here now, in the same way that the courts have completely ignored Part 1 of the Constitution, whereas this country is founded on the principles of the supremacy of God and the rule of law. This has been ignored, and this is in the Charter.
Yeah.
And the other thing that they've done with this, they've called it a preamble. We did not call it a preamble. There's no preamble description by us in the Charter. That was the first words of the Charter. And it's the lawyers and the courts that have determined the description preamble on it. It is the opening words of the Charter. And at the end of it is a colon, which means everything comes after this. In other words, everything is subject to the supremacy of God and the rule of law. And all of the decisions since '82, which have been made on the Charter, are unconstitutional because they have not recognized the supremacy of God and the rule of law and made that a consideration in any decision that they made.
Okay, you're saying, Brian, that when first ministers were around the table, you put that colon there on purpose.
Totally.
Deliberately.
Okay.
And it wasn't a preamble.
In the same way as there are other places there are commas and periods. We put them there deliberately too.
Yeah. So you're saying this is not a preamble, really. This is a guide. These are the guideposts. These are the instructions.
These are constitutionally obligatory guideposts for the courts to have to consider.
Yeah. Well, I tell you, if the Charter was used in that way, in the way it was intended, I can think of a whole bunch of decisions that would be right out the window right now.
Absolutely. And it is a disgrace. It's a disgrace to the law schools of Canada and to many of the lawyers. There's only a few lawyers around who actually even have the courage to write me and say, I agree with you. You know, they'll say it in a private conversation or a private email or whatever. Very few of them have said it publicly. But they have let our country down. They have let our constitutional down. And it's very, very sad. And none of these lawyers, by the way, or professors of law and all the rest of it, ever talk about the originalism concept as manifested itself in the United States. University of San Diego has most of the law school has to do with originalism. You can go into their website, and it's all about how originalism is alive and well in the United States, and how they are, through other professors of law and lawyers throughout the United States, still involved in this this originalism concept, and are very much pushing it. And this is why the Supreme Court of the United States has, in some instances, through Judge Alito and Judge Thomas, especially, and sometimes Neil Gorsuch and as well, and John Roberts sometimes, have ruled as they have and upheld various parts of the U.S. Constitution because of that original argument, which is still valid. Listen, we have an opinion. Part of the Constitution of Canada and the Charter was not only for the Charter, but also to get an amending formula. We have an amending formula now.
Yeah.
And our Constitution can be changed by Canadians. We don't have to go back to the British Parliament, right? We went from 1927 to 1982, 10 times to try to get patriation and our own amending formula, and failed. 82, we succeeded. And so if somebody wants to change the Constitution, judge of the Supreme Court, judge of an appeal court, you are not the ones to change it. It is a process of an amending formula that's in the Constitution that's supposed to be done under. And until that is done, what we wrote is supposed to remain in effect.
No, it seems right now that we've got 9 people unelected that have the ability to change the Constitution, whereas me and you as regular citizens, we need 50% of the population. Was it 50% of the population, 75% of the provinces are? Right. It's so it's the burden on us is much greater than it is on the unelected 9.
And they're not supposed to have any burden at all. They're not supposed to have any involvement at all. They're only supposed to interpret what's already written under the guideposts that are provided, like supremacy of God and the rule of law. So the whole system here has been completely undermined, right?
Hijacked.
Completely hijacked. We've been hijacked since 1982.
Well, we talk about laws that should be thrown out. I know that there's no originalism in Canada. What we have is we've been told that we have the living tree, where the Constitution and Charter can change day by day depending on how society is feeling. Could we talk about one law that is really bugging me? As a matter of fact, C3RF is going to mount a national campaign against this law. It's Bill C-63. It's the Online Harms Act. And when we look at that, you look at that and compare it to the Charter, it has things like you can an anonymous person can make a charge against you that he thinks you might say something hateful in the future, not even in the past, in the future, and he can get you. He could get you in before the commission, the Digital Commission, Safety Commission, and the commission can put leg irons on you. They can put you in house arrest. They can give you a $70,000 fine. They can, your life is ruined. Now, when you look at the Charter, I mean, there is a section in the Charter that says Section 7, I believe, you have a right to life, liberty, and the security of the person. Yeah. Now, where's the security of the person when you can be thrown into a hoose cow because you're thinking something bad?
Yeah, and of course the whole question of equality before the law, which is a provision of the Charter, right, and freedom of expression, all the rest. By the way, the other thing that the courts and the law and the governments have done, and you may have heard other people refer to it over time. If you read a lot of constitutional law, you'll come across the whole business of administrative tribunals.
Yes.
Right? Administrative tribunals, which are supposed to be really subject to the Constitution, which have really come up as a sidebar to the Constitution and have sort of replaced decision-making power from the judges themselves to these administrative tribunals and whatever judge or whatever judicial person is going to rule on that. And if you notice in this act, the C-63, you got the same thing. You got the Digital Safety Office, right? The Digital Ombudsman, right?
Yep.
And so these are layers of administrative, processes and hearings that will go ahead, which are going to replace more or less the Constitution.
Yes. Yes, they've inserted themselves in between the citizen and the Constitution.
Exactly. exactly. And so the structure itself is injurious to the intent and wording of the charter, the structure itself, and then you go to what they actually do, as you just outlined, can define what misinformation is or what hate is. They can define it. Parliament doesn't define it. They define it. And so that therefore the charter has been stripped of all of its meaning when you have this kind of legislation, which is past first reading, now into second reading. Quite likely when the Parliament now reconvenes, this is going to be brought back to for second and third reading. And it behooves the MPs and the so-called senators to stop this madness.
It is madness, because I cannot see Canada where there's any free speech. If this bill gets passed and it goes through and becomes law and is enacted, for example, I'm going to be thinking twice about what I'm even thinking about, because someone might be in the corner watching me and is ready to report me and ruin my life. And so, even though I consider myself a patriot, someone who fought for his country, I'm going to be shut out. And,
exactly. And you had to watch your conversation with your friends, and you had to watch your conversation. You're out to a restaurant somewhere, and you started to be more frank in talking to somebody about something, because there might be somebody at the next table who overhears you and considers what you're saying to be, you're thinking about, right, and then bring that against you to these kinds of tribunals under this law. Look,
I like the way that you've introduced this whole idea of tribunals imposing themselves between the charter and the citizen. Another aspect of these fake and phony institutions that are taking over authority from the charter are the international ones, and I'm thinking about the World Health Organization, the recent regulatory structure that was put in place, and Bill C-293.
Yeah, absolutely.
Which instructs Canada to follow through with something called the One Health Authority, which is vested in the World Health Organization.
So we have not only lost our charter and our constitution, but we're losing our sovereignty, which is supposed to be guaranteed in our constitution. We have relinquished our sovereignty to international tribunals, but it's all consistent. We're losing it to our tribunals within the country, and we're losing it to tribunals outside the country. And so this is all very consistent in the way a lot of people today think about governance for the world. They're thinking about governance lacks the kind of structure and strength that, like, even Count Montesquieu talked about in his Spirit of the Laws back in the 1600s, right? Which, by the way, Montesquieu's ideas became very much a part of the federal constitutional people in the United States when they were forming their constitution. Montesquieu was a well-read person by Madison and the others who were the fathers of the Federalist Papers. And later, of course, you got the other important people who were involved in constitution making as well. But so this whole concept of the nation state, which arose out of the Middle Ages and the late Middle Ages into forming communities and countries and then nation states, has now evolved to where internationalists want to blur the lines between the sovereignty of a national state and the power of international agencies. And European Union, you see it in the European Union, and why the Brits, by the way, denied the complete capitulation to European community.
Yes.
My understanding from before he's dead now, Roger Scruton, who you might remember, the great British philosopher who died suddenly only a few years ago, has written some fantastic books on constitutional law and the right of the individual. He, in a lecture, when he opposed this whole Brexit thing, talked about going around rural England, and suddenly the farmers began to realize that they had to agreed to a quota that was established for wheat in Brussels.
Yeah.
And it was because right on the ground, this is the problem with democracy. People theoretically don't get it, and they only get it when it's too late and it hits them right in the stomach. And so these farmers throughout rural Britain suddenly realized that they were no longer subject to the laws of London, that they were subject to the laws and quotas for their economic activity as a person in England to Brussels.
Yes.
And it was as a result of that that there was sufficient groundswell throughout England to oppose this Brexit move. And very interesting, very, very interesting. And so I've always taken the view, and I'm a bit of a student of history. I did a lot of economic history at university, and right from I did a major essay one time on the role of the Athenian Navy in protecting Athenian democracy, for example. I'm very much, I studied the classics, and I studied all of Middle Ages, late Middle Ages, and so on. I'm very much a student of history and the evolution of man's organization, if you will, for want of a better word. And I came to the conclusion many years ago that when you go beyond the bounds of the jurisdiction, sovereignty of a nation state, right, it takes you beyond any power that the individual will possess.
Yes.
As you get away from that, right, power then seeds itself, and your influence or your MLA as an influence or your MP as an influence is diminished.
Yes.
And therefore, the power of people to have some say over their governance becomes meaningless. And that's what happens when you get into where we are now with these international organizations.
Well, we're outsourcing all of our political power, our citizens' political power, to these domestic and international tribunals, like you say. They are not elected by us. They're not going to feel sorry if they hurt us in any way, because they're going to get their paycheck anyway, and they're not going to get fired. They're doing their job. And in effect, basically, with everything else that's coming down the pike, with all these new regulations and controls and strictures that are being putting on citizens, like now they're talking about central bank digital currencies. They're talking about really tying us up in shackles and making us mere cattle.
They already have. And it's just.
I see a big. There's a big conflict coming here. In our own constitution, in our own charter, Brian, as you know, because you helped write it, there's a section that says that any law that's made that is not in line with the contents of this charter are of no force or effect. So all these things that they're doing, these administrative tribunals all over the world and inside Canada, they're illegal.
Yeah, absolutely, totally. But on the continuum, if you go from zero to if you want to go from 0 to 100, if you want to go there, we've already entered the period where we've lost or losing our sovereignty and losing our power as a people under the Constitution. So we're over 50%. If you talk about the continuum, we're over 50% lost in our constitutional legitimacy and our power as a people. I think people got to understand that. People say our Constitution is threatened. No, it's not threatened. It has been threatened, and it has, and they have broken. Right, they're inside the gates.
Yes,
they're inside the gates.
The Constitution and Charter is under attack. They're inside the gates now. How is this going to pan out? I think you gave us a clue there when you started talking about Brexit in 2016. There comes a point when people start to realize, hey, this is crazy. This is not where I want to go. I'm going to vote against it. Let's have a referendum. Then we saw what happened in 2016 again with Trump. No one expected him to come out of the woodwork and become the president. But there were enough people in America who said, there's something going on here that I don't like to smell of. In Canada, we had Freedom Convoy 2022. That was totally unheard of. Canada never puts together something like that. And that's a movement that has now impacted movements around the world. People are still using the Canadian model to protest.
But the problem is it has gone nowhere in the constitutional sense. That's the problem, right? We have done our protests, and now it's over, and now we're gone back to sleep again. Rather than that needed to be continued in some other form, right?
Yeah.
And people didn't push for actual accountability and transparency. All these mandates and lockdowns that were unconstitutional, right? They have not been held accountable, and there's no independent inquiry, and Parliament should be involved in all of this. This is where we've lost. This is where our democracy has been lost. Is that MLAs and MPs don't even know their power anymore.
Yeah.
Through the COVID period, Russ, and I have not made this public all that much either, is that I was contacted by MPs all over Canada. And I did Zoom calls with them like I'm doing with you today, where I went through the history of how the charter came to be. I took them right back to 1867, came up through, and then dealt with 1981, 80, 81, and 82, and then finally getting the charter. And I went through the main components of the charter. Sometimes it took, I would speak for anywhere from 60 to 70 minutes. Other times I would break it up and have them questions and answers in between, or wait till the end and have questions and answers. We'll go on for hours.
Yes.
To a person of all the MPs that contacted me, some of them ended up being like 15 and 16 MPs at the one time on the one Zoom call.
Okay.
To a person, they did not realize what the charter was, nor had they ever read it.
Oh boy. Wow. Wow. That is an eye opener.
Nor did they understand their own, in their MLAs, their own system. I'll give you a really classic example. One Zoom call with community groups that I did. This wasn't just with MLA. This wasn't an MLA initiated one. This was by citizens in Hay River, Northwest Territories.
Yeah.
And Yellowknife. A person up there got a group of freedom lovers together. He was watching what I was saying and in online, watching what was going on, the beginnings of the truckers convoy and all that. And a lot of people contacted me, and I did 200 to 300 of these all over Canada. Okay. Not 10 or 15, hundreds.
Yeah. Wow.
And I had this group of 40 or 50 people. Okay. One of the people in the group was an MLA.
Yeah.
A lady from Yellowknife. She was on the call. And so I gave a presentation of 30 or 40 minutes. And I explained to them ahead of time, just stay with me while I go through this. I won't spend too much time on any one thing. I'll try to keep your attention and go through it. And when 30 minutes went by, and I thought I was going on too long, and I said, is everybody okay? Everybody shouted, keep going, keep going, keep going. We're all here. And we're listening, we're really listening. And so I finished it. Yeah. And I went through it, and I started to talk about how a lot of people don't even understand our system within our own little legislatures. And I spoke about when I was premier and how we had to have a caucus when we brought in new legislation, right? And the MLAs could even force this if they wanted to, right? If some leader, some premier wasn't going to go ahead with it. Because there's always caucus meetings before you have your legislature, right? You're planning things and so on. And so I would force, obviously, the ministers got the message really early on, that any new legislation coming up through their department would have to go to caucus and be debated. So we had caucus support before it was introduced into the legislature. Not just by some minister saying, you have to support me when I bring this forward. You have to debate that with that member in caucus. Yeah. When I raised that, the MLA, she identified herself. And she said, my name is so-and-so, I'm here in Yellowknife. And I now realize that I'm not doing my part as an MLA because I have the opportunity with my colleagues to go to the leader and say, we want a caucus meeting on all new laws that are coming into effect. And I mentioned this afterwards to many other MLAs and MPs, and they were absolutely flabbergasted. And I said, you have the power to do that. get your MLAs together, and you have the power to do that within your own government. Within your own
Good.
government. And so,
No.
but I always say, Russ, that democracy is only as strong as the civil engagement of the people.
Yes.
As the civic engagement of the people diminishes, so does your democracy. And that's where we've fallen down, is that even MLAs, let alone teachers and professors, don't understand our system. And citizens don't understand our system. So that therefore, we've fallen down on the job as individual voters and citizens of the nation in holding our MPs and MLAs accountable. For example, I said to people in a church, I couldn't get a public hall to by the way, to speak in here on Vancouver Island. And so I had to, the fundamentalist churches allowed me to speak and rent their space. Freedom groups would rent their space. And I would speak. And I had one in Black Creek between Comox and Campbell River on Vancouver Island. Yeah. Had the place packed, packed right full of people. And as a matter of fact, we had to keep people outside because we were breaking the fire regulations. So many people turned up. And people were flabbergasted when I explained to them how their MLAs and MPs and how they, as individual citizens, I said, you can go out tomorrow and with your people now that you have, you know who's with you in Black Creek or in Campbell River and Comox, and you can go as scores of people and meet with your MLA and say, we want a meeting
that's key.
Every quarter to talk about what you are doing for us in the House of Commons while the House of Commons is open. Yeah, we want to meet you, and we're going to track the legislation and how it affects us. We want you to agree to a meeting every quarter while the House is open. And they said, can we do that? And I said, absolutely, you can do that tomorrow. This is where civic engagement has not, we're not following through. Once an MLA gets elected or an MP gets elected, we let them go free. And we should not do that. They should be held accountable every year, every month, that they're members of the legislature or members of the parliament.
I think those are great points, Brian. That the fact that our MPs or MLAs are they're being seconded. They're being seconded by outside forces of these administrative tribunals, the domestic and international. And it's up to the citizen to call them to task. I mean, and if we don't,
absolutely, and the MLAs can force and the MPs can force that if they bring forward a private members bill, it has to be debated during that session.
Okay, yeah.
Right now, you go to an MP and say, I want you to bring in this private members bill. And that MP will come back and say to you, well, it might take 2 or 3 years. Or it might even get debated in this session. We'll have to wait till after the next election. That is ridiculous. That's not democracy.
No. As a final question, I got to ask, Brian, what's next? What's next on your plate? Where are you going from here?
Well, I'm trying to get over the whole what's happened. I'm trying to get over, especially the court decision.
Okay.
And that's difficult. That's really tough because, as I said to you earlier, I really thought at the Supreme Court of Canada level, not at the Federal Court of Appeal, not at the Federal Court, but at the Supreme Court of Canada level, that there were still enough justices. I know of them, and I knew one of them, who was in the former life was a legal advisor to John Crosby when he was a minister in Ottawa, and who was from Newfoundland, and who's now on the court. And I thought he and people like him, who I knew there were like-minded people now on the court like him, would have forced at least a hearing.
Yes. Okay.
I'm almost crying.
Yeah.
Because I really believed, looking at and most of these judges, to their credit, do read the federal court's hearing. They would have read the discovery stuff. I would have read, right, the evidence that was provided. And
Yep.
seeing that the government of Canada had absolutely no evidence to sustain that travel mandate, that alone will be sufficient for them to hear the appeal that we brought forward.
Well, as it stands now, like the people look at that and their decision, and all they're looking at is an abuse of power.
Absolutely. The other thing that really struck me going through this court case, I was reading Hannah Arendt's book, The Origin of Totalitarianism.
Yes. Familiar with it? Yeah.
Halfway through that book, where she talked about a certain group that was being within one of the European societies, which was being, not provided with appropriate rights. She used the word, and I brought this up to my lawyers when we appealed to the Supreme Court of Canada, the right to know. Under any democracy that worth the name, the right of a citizen to know whether their government has violated our rights under the Constitution.
Yes, we have a right to know.
We have a right to know.
Yeah, and that's basically what Mosley said. Yeah, I think I thank you for this discussion, Brian. It's been spirited, and I've enjoyed it. This has been a great discussion. Thanks very much for joining us on our C3RF in hot session.
You're kindly welcome.
Okay. Until next time, Brian.
See you.